Robert, before we have them come in, I just wanted to mention just a couple of things.
Sure.
Officer Masters is, I'm only gonna have two witnesses, Peyton
Okay.
Collins and Rob Masters. He's the only one on duty right now, so he told me that if he gets called out, he'll have to leave. I told him it should only take a couple minutes, we'll have someone else on duty at 10, but I told him it would be very brief. And then I didn't know if he wanted to put on the record, and I know it was asked why there were parts of his video where you couldn't hear it, and that was intentional because it was inadmissible item, things that he was talking about. And so rather than play them and then have an issue with it, so it was muted. So I didn't know if you needed to put that on the record or.
I think because I think there were quizzical looks among the jurors yesterday about that. I assumed it was because of the reason you've stated, but we should probably tell them. Please be seated. Good morning, ladies and gentlemen. How's everyone today? Good. Before we call our next witness, I want to give you a brief explanation. You saw a video yesterday of the defendant's interview. Parts of that went silent. The reason that was silent, because those portions contained irrelevant information that had nothing to do with this case. So if you were wondering, and I know some of you had sort of a quizzical look yesterday when it went silent, that's why. All right? So are we ready to call our next witness?
Yes, Ron.
I see two hands. Yes, ma'am.
Yesterday, we have heard that it was at the filling station, and then we heard it was at Lights One Stop. And we need to know which gas station. They're two different stations.
I believe that could probably be
I think they'll have to rely on the testimony.
on the testimony. Yep. Yes, sir.
The thing, sir, was that at times the volume was too low, so today we could have it turned up.
Okay.
TV if there's any more videos.
All right. Okay, then with that, we will call our next witness.
Thank you. The State Patrol Officer Masters.
Morning. Officer, if you please raise your right hand. Do you swear to tell the whole truth and nothing but the truth in this matter, so help you God?
I do.
May inquire.
Thank you. Sir, could you state your name and your occupation?
Robert Masters, Sergeant with Jackson Police Department
And how long have you been employed?
since 1999.
You have in your hands what's been marked already as Plaintiff's Exhibit 7, is that correct?
That is correct.
And were you asked to test fire that firearm?
Yes,
And was it operable?
yes it was.
And did it fire, in fact fire?
Yes it did.
No further questions.
Anything from the defense?
No problem.
All right, thank you.
Mind if we amend that?
We'll need the exhibit.
You need this?
Yep.
You don't. Okay, thank you.
You don't sign for it.
Yeah, thank you.
I do have one question. And that consent vote was case examined the gun to determine whether it is presently unloaded.
What is the question?
Is the gun in the box unloaded right now?
Yes, it is unloaded. The magazine is in, the chamber is open.
And would the court mind if I gave this to court staff to maintain, or how would you prefer to do that?
John, would you take control of the that exhibit?
The state's next witness would be Peyton Mullins.
Ma'am, would you please raise your right hand? Do you swear to tell the whole truth and nothing but the truth in this matter, so help you God?
I do.
Thank you.
And could you state your name and where you're employed?
Peyton Mullins, I'm not employed anywhere at the moment.
Can you tell us where you were employed on July the 30th?
Jackson Food Mart,
And where is that located?
970 East Main,
I'm sorry?
970 East Main.
Do people call it by any other names?
The Exxon or the old Mike's one stop.
And can you remember back to July the 30th of 2020?
Yeah.
Is there a reason why you remember that in particular?
Yes, I was working that day and an incident happened.
Can you tell us a little bit about what you know?
I was in the kitchen of the store at the time and 3 older ladies had come through the door freaking out, telling us to call 911. So we had asked what was going on and they said that
This one, I would have officer, but the truth of the matter was.
You to approach,
Can you tell us a little bit about the
Counsel.
demeanor of these women?
sustain the objection at this point.
Can you tell us a little bit how they were acting?
They were acting scared, like terrified.
And then based on what they told you, what did you do?
I had told them to get into the store just in case anything else had happened outside, and then so there wasn't a fall.
And then what did you do?
Then we had called the cops because we seen bickering and physical and mental like abuse outside because we had heard it because we had the doors open at the time. So we heard everything kind of.
Tell me about what you heard first.
He was cussing at her, telling her that if she didn't get in the effing car, he was going to shoot her. And she was screaming that he had a gun.
And then what did you observe?
I seen him shove her into the car, like up against the car.
And do you think you would recognize these people if you saw them again?
I barely really seen their faces.
Did you observe anything else?
No.
Did you see what type of car it was?
I don't remember what kind of car it was. It was like older.
And then did you deal with the police at all afterwards?
Yeah, we had to call in my manager so she can go get the camera footage and everything.
And did you know these people
So people,
that were involved in what was going on
no, I did
outside?
not.
I know for the first thing.
Thank you.
Cross.
Ms. Mullins? Good morning, my name is Hinkle, I represent this fellow over here. Did you exit the store to look at what was going on?
I went to the edge of the door,
Was there anybody else with you?
just my coworker,
Who was that?
Angel Gillum.
And if I understand correctly, you see two people standing in the lot somewhere around the pumps.
They were by the pumps and they were arguing outside of the car. They were arguing outside of the car.
How close were they to the car?
As between the car and the pumps, there's,
Between the car and the pump?
Yep.
Did you see whether it was a young woman and a young man?
that I didn't see.
Did you see the young woman push the man?
No, I did not.
And did you see her push the man twice? You have to answer out loud.
I did not.
And you say you saw the young man shove the woman up against the car?
At the time I had walked out from the kitchen, I had seen him shove her up against the car.
Shove her up against the car? This car next to the pump?
Yep.
Any further questions? Thank you.
Anything else of this witness?
Nothing further.
Okay, ma'am, you're excused.
Thank you.
Next witness?
No further witnesses.
So we would need to deal with admission of exhibits and maybe a little motion practice at this point. Ladies and gentlemen of the jury, we now have some procedural matters that you don't get to hear or participate in. So I'm going to have you sit in the jury room for a little bit while we take care of that. Thank you.
All right.
Maybe you turn on the fan in a few minutes, then it'll.
Market freeze setting over there.
Uh-oh.
Please be seated. Let's deal with the exhibits. I have 1, 2, 3, 6, 7, and 8. Okay. Any objection to the admission of Exhibit 1? Exhibit 2?
Do you identify that?
That would be the video from the patrol stop, from the dash cam. And then Exhibit 3 is,
I'm sorry, I couldn't hear what you said.
yeah, I just thought I'd pause to see if we have any more loud crashing from, I think they're taking the dumpster. Is the, your client's recorded interview with JPD?
With the understanding that, no objection.
Okay. Exhibit 6 is the rights form that he signed. Exhibit 7 is the gun.
No objection.
And number 8 is the submission sheet for the gun. Okay. So that would be all the state's exhibits that have now been admitted.
Yes, I would indicate though, just 2 things, so that if it goes back to the jury, we don't have an issue. The first one is the store video, has all 4 videos on it. We played 1 and 4, and not 2 and 3. So we could probably take it back and redo that before it
Goes
to
back?
the jury, but I wanted to bring that point up.
Okay.
Yeah, second point is the trooper video we played, I think I indicated, it was 18 minutes and something odd seconds.
Something, yes.
The video continues on for some time.
Mhm.
We didn't use all of that video, so I wanted to make that point. I'm not exactly sure how I would go about cutting off a video, to be honest with you. I don't know how to do that. I wanted to make sure that the court knew that there was longer than what we played.
When I've had videos before, I have not had the jury ask to view them again. Although in this case, I can see that's a likelihood. What I have proposed before is that we would bring the jurors back in and we would play it for them. Because I'm not sure how I guess they could go back with the laptop and just view it, but
That would be okay. The only thing I would ask is that they don't deliberate while
yes,
you're recording.
they would be instructed that they're just to come in to observe it and then go back in for their deliberations. That's what I've suggested before, but I don't know how that sits with counsel in this case.
I think that's probably the safest way to see which portion of the video.
I only played less than 19 minutes. I tried to get it at 20, but then I just.
I think it was 1837.
Yes, I think that's correct.
No, the one with the trooper. So I played just the trooper video.
Video that they're going to be concerned with is
Some,
seeing the audio. Question.
there were parts on that trooper video that I don't necessarily know that having volume on. It's just really hard to hear.
I think
On the outside of the troopers.
my notes indicated we played it to 1857. That was the trooper video. So, is there anything else from the state? So the state is now rested. Mr. Bulger, is there any motion practice you would care to make? Let's stop. We have an alarm on our recording system, and I want to make sure that we are actually capturing this. Okay, so it's replay. Let's replay the last minute. Let's see if it's picked up. If you've got a phone, turn it off. I won't ask twice next time you'll exit the courtroom.
Would it be okay if I checked to make sure this thing's empty? I wanna make sure I didn't leave it in the.
Ma'am, is your phone off? I'm not asking you, sir, 'cause it's not your phone.
It was fine, I'm sorry.
So it's off.
Yes,
You understand if it goes off again, you will exit the courtroom.
yes.
Okay. Yeah, well, that's why I want to make sure. Seems like it's picking up.
No, we didn't end up playing it.
Do we go back to, I want to make sure we can go back to recording now.
You are, yeah.
Okay.
I just turned the speaker off.
I can still hear it. I want to get that off. Okay, that's all right. All right. Mr. Bulger, any motions you care to make?
With respect to count one of the indictment, charging
It's just where he's speaking softly.
Mr. Bulger, if you would keep your voice up a little bit more, that would be
Yeah, it's
great.
recording him, it's just.
Your Honor, with respect to count one, Rule 29 of the Bible is criminal procedure. The evidence is insufficient with respect to the entire set of elements of the crime. For a reasonable trier of fact to conclude that those elements have been proven beyond a reasonable doubt. The language of the particular subsection, A3 subsection, states that prohibition is against force or threat or deception, removing, in this case, Nicole Hinkle from the place where the person was found. With respect to that particular element, we have no proof whatsoever of removal. I think that the state is relying upon restraint of liberty of Nicole Hinkle by threat of force, by force or threat. There's no evidence of deception in this particular case, so I think we're narrowing the presentation to a restraint by force or by threat. We have the testimony of the victim herself indicating she did not feel she was being kidnapped. She does indicate that she felt fear because of what he had done in the way of threat within the confines of the motor vehicle. It seems that the statute contemplates sequential. The behaviors. First, there is a threat or force that causes a restraint of liberty. In this case, we have a threat and force that's been related by both of them. He grabbed her by either the hair or the back of the neck, pushed her down to the console. That would constitute force. He has a firearm. He's threatening to use it with her. He doesn't, but threatens it. So we have, we've come to that point where the elements seem to be in play, but there is the absence of any circumstantial evidence that he is acting with a purpose to cause serious physical harm. He has a loaded firearm. He does not discharge it in any fashion. He, with his physical activity in relation to her, doesn't leave a mark. There's not a red spot. There's not a bruise. There's not a scratch. And the victim, the alleged victim here, Nicole, exits the motor vehicle. There is further physical contact, but she concedes that she returned to the vehicle willingly, and that the progress from the filling station as he operates the motor vehicle is at her request, essentially. Let's get out of here. I know what I've done. The police are coming. It seems to me that in this situation, we don't have any evidence that there was a purpose on the part of Tyler Maynard to further terrorize. Now, there's I think a confusion here is whether the threat constitutes a sufficient evidence of an intent to terrorize, a purpose to terrorize. The threat, I believe, ought to be isolated. He made a threat, but what was his purpose? It was to restrain her in the automobile rather than let her leave unaccompanied in a strange town with no means of transportation, some 50 or 60 miles from the place where she lived. Now, is that a purpose to terrorize? That seems to be what she acknowledges herself when she gets back in the car and encourages him to leave the station because the police will be arriving, and she doesn't want him to get arrested for the scene that she has created on the surface of the filling station. In this particular instance, I think that if we accept that this is a sequential series of elements, sequential in time, that there is not sufficient evidence for a reasonable trier of fact, especially in the face of the victim's own denial that she's being kidnapped, for the case that we submitted to the jury. With respect to count 2, the abduction, it's in a more general phraseology indicating the absence of a privilege. We don't maintain there is a privilege in this situation. We have acknowledged that there's evidence out of the mouth of both of these individuals that there was a threat and some force, and there was a restraint of the liberty of another for a brief period of time within the confines of the automobile. So I don't think that the same argument applies to the abduction case. And we'll restrict the Rule 29 motion to count 1.
Okay. For the state.
Thank you, Your Honor. As the court's well aware, Rule 29 requires the court to make its determination, looking at the facts in the light most favorable to the state. What we would indicate is that the alleged victim, Nicole Hinkle, her words were merely of what she perceived and not under the Ohio Revised Code definition of what kidnapping is. So we must return to the definition of kidnapping, which requires that by force, stealth, or deception, restrain the liberty of Nicole Hinkle with purpose to terrorize the said Nicole Hinkle. And looking at the evidence in the light most favorable to the state, the court could find that, of course, he used force in this particular case, 1, by pulling her down back into the car, and 2, by using a firearm in which he threatened her and threatened her life with that. His intent was to restrain the liberty of her, to keep her in the car, and to keep her from leaving that said vehicle. His purpose in that, he had more than one purpose, but he indicates in his statement that his purpose was to scare her. I think that's fairly clear by his behavior, threatening to kill her, grabbing her back. So as far as the terrorizing, he wanted to scare her so that she would not leave. And I think that falls within the idea of terrorizing when someone threatens their life while holding a firearm with them. Certainly the intent is to terrorize to the point of, scare them to the point of terrorizing them so that they will continue to do what the offender is wanting them to do, which in this particular case was to stay with him and not leave. So we do feel that the elements of the offense were met in a manner sufficient to go to the jury in this case.
Do we have a definition of to terrorize?
We have a common definition that would be available to the court, just the dictionary definition of the word terrorism, which is to cause terror. I would believe that would fall under to scare them, to terrorize, being that he threatened to kill her and put her in fear.
All right. Yes.
Right at the point that the state is attempting to use as evidence of a threat sufficient to cause restraint for a dual purpose. A threat that causes restraint, if it's going to be effective, has to induce fear. But the statute contemplates something further, and that is that the threat that causes fear be made for a specific purpose, and that is to either cause serious physical harm or to further terrorize. And I think that the use of the word further terrorize is important in this situation. The threat itself can't serve both purposes, in my opinion, with the state. And so that I think is really the heart of the argument here, is that there was, in the mind of the victim as she's related to us, no further terrorization after the initial threat, which caused her restraint, her brief period of restraint. And she understood that she was voluntarily re-entering the vehicle, and there has to be some notion, I think, of duration here, or just a temporal sequence of events that we just don't have in this case, with respect to the purpose to terrorize.
So are you suggesting there would have to be two separate incidents?
I'm not suggesting that there would have to be two separate incidents, but I'm suggesting that the occurrence of a threat does not serve to establish a purpose to terrorize. The threat has to be in place in order for the initial elements of the offense to be satisfied, the restraint. Threat causing restraint is not evidence of a purpose to further terrorize. That's essentially our argument.
Okay. Do you have any case law that you can point me to?
I do not.
Okay. Well, I'm going to deny the Rule 29 motion. Now, does the defense intend to call any witnesses?
Your Honor, we do not.
Okay. All right. While I have the jury back there, Mr. Bulger, you had an opportunity to look at the jury instructions. Okay. Any comments?
No.
Okay. So I guess I should be more specific. Any objection?
Remember that we do have, I think, optional instructions with respect to the defendant's testimony.
Yes.
We would, I think, ask the court to give the what's labeled possible instruction on that. The pages are.
Yes. Yeah, the possible instruction does not testify. It's not necessary that the defendant take the witness stand in his own defense. He has a constitutional right not to testify. The fact that the defendant did not testify must not be considered for any purpose. So we would give that instruction. Any other requests or objections to the instructions?
Your Honor, this, am I to understand that the proposed instruction would be the complete instruction that the court intends to give?
Yes.
Some of these seem to be in accordance with the MPAI pattern instructions. Given that I'm further objection.
Okay. So I just get these in final form. What else do we need to do before we would go to closing arguments? Anything else from the state? Anything else from the defense? Okay. So, we'll just get these in final form and then we should be ready. Actions by the defense.
No, Your Honor.
Okay. So we are ready for,
To one procedural matter.
sure.
I would like to rest.
Yes, we need to, yes, we need to do that. So I think you would prefer to.
Yes.
Okay, so let's bring them in. I'll go ask if you're going to present.
And after our rest, I would make a number Rule 29 of the same tenor.
Sure.
On the same count.
Yes, I think you have to do that.
All right.
Think we forgot about it? Yeah. We're ready for you.
Please be seated. The state has rested at this stage. It would now be the opportunity for the defense to call any witnesses. They're not required to, but if they desire, now's that opportunity.
Your Honor, Mr. Maynard had to answer a question asked of him immediately after the incident. We're not representing any evidence that rely on the jury's consideration of this statement.
All right. And then, counsel, if you want to approach.
We would renew our Rule 29 motion with respect to count one, allowing further operation of the argument.
All right. And I'm assuming the state's relying on its previous argument.
Yes.
Okay, I'll deny that. We are now ready for the closing arguments, and we'll hear from the state first.
Good morning. Thank you for your patience over the last couple of days. What we're gonna do is just review and renew our understanding of what the evidence is. On July the 30th, 2020, at the Exxon gas station in Jackson County, Ohio, there was a disturbance out in the parking lot, enough to the point where the workers at the gas station called the police. They were extremely concerned. Older people were scared. They came into the store to seek protection. And they were given protection and taken to the back of the store. Workers there called the police. They were also able to hear and see some of what was going on. And they also were able to review video and secure portions of that secure that video for law enforcement. And they did it in the way that they could do it and give it to the police. They also provided an accurate description as well as license plate number for law enforcement to locate. And they gave that information so that law enforcement could in fact find them. And you heard from Trooper Dunn that based on the information and the accurate information, the descriptive information that he was given, he was able to locate a vehicle with the same description as well as the same license plate. And as a result of this, knowing that a firearm at that point was alleged to have been used, he took proper precautions. Trooper Dunn indicated that he pulled the vehicle over. He had both occupants of the vehicle removed from the vehicle because at that point, he was primarily concerned for officer safety at that point, knowing or having reason to believe that a firearm had been used at the gas station, as called in by the workers there. So we did have them come back and secured both parties to make sure that they were safe. And you'll get the opportunity to review the video. And the video does show what happened at that stop. You can hear some things that go on outside and some things that are said. It's a little difficult to hear them because of the type of having a video showing outside what's going on. But you have enough opportunity to see that both the two parties that were stopped are the same people in the videos you'll see it from the Exxon station. And you'll have the opportunity to witness some of the defendant's behavior and his mindset when he was in fact stopped. Calm to out of control. And that's what they were dealing with that day. Calm to out of control. So based on the information that he was provided, the officer has to deal with the defendant. And what he notices about the defendant is this fanny pack that's strapped across his chest. And if you listen closely to what the conversation between the officer, the trooper, and the defendant, the trooper Dunn inquires about why he would be wearing a fanny pack across his chest in that manner. And the defendant initially denies the reason for it. And the trooper questions him again. No one wears a fanny pack like that. Why do you have a fanny pack on like that? Like no one wears something like that. It's at that point that the defendant finally admits that, well, I had a firearm in there, and he gives the information to the law enforcement. Sergeant Dunn goes to the vehicle and he locates that firearm underneath the seat, the driver's seat. And you'll have the opportunity to look at that firearm. And you can review the testimony that indicated that it wasn't just a firearm, but it was a fully loaded firearm. It had one in the chamber and a completely full magazine ready to be used. And this was in the hands of the defendant that we see goes from calm to out of control. He was the one that possessed it. And you also heard testimony today that that firearm was operable because it was test fired by Officer Masters. A firearm in the hands of an untrained person. In the hands of someone that uses it to threaten, scare, and control his girlfriend. You'll have the opportunity to go back and look at the videos from Exxon, from the gas station. Video that they just used to record everything that's going on for the day. And you can look at them and you can see what took place. You'll see the car. And you can see a female attempting to get out of the car. And then you see that female jerk back in to the car. And she remained in the car. And then the defendant exited the car. And it's at that point, you'll see the female get out and run away. What were the defendant's actions at that point? You can see it. He approaches her. And he continues to approach her. And she backs up. And he approaches her again. And she pushes him away. And he approaches her again. And she pushes him away. And he approaches her again. In an aggressive manner. You'll have the opportunity to watch and review his behavior on that day. It's recorded by the Exxon videos. He continues to aggressively approach her on each occasion. She pushes him away and he continues to approach. He's still got the fanny pack around his chest at this point. You can see it in the video. And he goes up to her. And she says, he gives her a hug from the man who's still wearing a fanny pack with a firearm in it.
Objection, Your Honor, that's not evidence.
Approach.
There was no testimony that the gun was in a fanny pack at that point in time.
I thought he said that in this.
I believe Mr. Bulger is correct. I don't think we had testimony. I think there's testimony that in the police station that he would carry the gun in the fanny pack, but at the exact time at the gas station, I don't think we have that testimony.
I'll correct myself.
All right, thank you.
Gonna correct myself, and I apologize. The fanny pack that he's known to carry the firearm in, he's still wearing it on him as he approaches her again. And you'll have the opportunity to view that from the video. You'll see that after this brief time that they're together, you see how she walks back to the car and at what point he is behind her. And you can see that he walks directly behind her as she goes quickly back to the car. He's behind her on every step, getting her back to the car. So you have an opportunity to see the video and watch the video. The car pulling up, the car sitting at the gas pump, the defendant out getting gas, the fanny pack on him at that point, the fact that he gets back in the car, you see the girl try and get out, and you see her immediately go back into the car. And then you see her get out quickly again and run away. And the defendant continuing to approach her aggressively. And then eventually leading behind her, going behind her directly, directing her again to the car. You'll have the opportunity to watch that. And then you'll hear what happened inside the car. You heard it from and reviewed the testimony of Nicole Hinkle, a young girl that was 17 at the time. She indicates that while in the vehicle, she tried to get out. He grabbed her, pulled her back in, pushed her onto the console where the ice cream was, and held a gun to her side, at which time he threatened to kill her. And you'll hear that this is also the same information provided by the defendant. Go back and listen to his interview with Officer Kate, in which he indicates that he held a gun to her stomach, that he pulled her either by the back of the neck or the hair, and pulled her to that console, had a firearm in his side. He indicates a couple of different reasons in his interview. He wanted to scare her. This is how he gets her to do what he wants her to do. It's the only way he could make her stop. That's the only way he could make her stop. Those are his reasons. He fears that she's going to go to the police on him, he tells the officer, and he was in fear for his own freedom. These are the reasons that he provides, and you'll have an opportunity to listen to the interview and go back and see his explanation, his reasoning, his rationale, why he would hold a gun to his girlfriend's side, why he would pull her back into the car and make her stay. Well, I will be asking you again to look at go back and review when the court gives you your instructions as to what constitutes these crimes. You'll be asked to see if they in fact fit. Not whether maybe they fit what we commonly think of the definitions, but whether they do in fact fit what the legislature has decided the revised code provides for the definitions of these terms. You'll hear, and again, you'll rely on what the court tells you, kidnapping can include by force, stealth or deception, restrain the liberty of Nicole Hinkle with purpose to terrorize the said Nicole Hinkle. So he restrained her in his vehicle. There's no information provided that requires a certain amount of duration or time that this has to take place. But that he threatened her, we have evidence from both the defendant as well as Ms. Hinkle that he restrained her. He pulled her back into the vehicle, he used a firearm to her side, and we have information that he threatened her. He even provides information that he did this with the attempt to scare her. She indicated that she was in fact very frightened. Looking at the abduction charge, abduction provides that did without privilege to do so, knowingly by force or threat, restrain the liberty of another under circumstances that created a risk of physical harm to Nicole Hinkle or placing her in fear. There's no circumstances in which privilege would apply in this situation, and he used both force and threats to restrain her liberty. We saw the force and how he drug her back, pulled her back into the car. We can see how her reaction and her behavior on that. And we hear also her testimony that he pulled her back by the neck. And then we hear the information provided by the defendant himself that he pulled her back into the car. He also threatened her by holding the gun to her side and threatening to kill her. This certainly created both the circumstances that create a risk of physical harm, a fully loaded firearm in someone's hands that's upset, putting it to her side creates a risk of physical harm. It also placed her in fear, as she indicated herself that she was, and he indicated that was one of the reasons he did it. You also hear instructions about the improper handling of a firearm in a motor vehicle. All the evidence indicates that the defendant had the firearm. He was the one that had it. He was the one that was in control of it. He's the one that put it under his seat. It was a fully loaded firearm, easily reachable by him without leaving the vehicle. Really no question that he was improperly handling a firearm. So when you go back and you look at everything, look at it as a whole, look at the circumstances that caused these people at Exxon to call the police, to get the license plate, to get a description, to have law enforcement go after them. This is the information. You'll look at all of this from what you've had the opportunity over all of the witnesses. Look at the defendant's behavior and the risk he put this young lady in and the fear that he put in her to do what he wanted her to do. Look at what the definitions are for these terms, kidnapping and abduction. He clearly restrained her liberty. And the issue that she eventually went into the car, you can look at it and use your own judgment when he is directly behind her the entire time getting her to the car. Also look at what her mindset was at that point. She'd had a firearm held to her. She'd been pulled back into the car. She indicated that she just had enough. But yet, all these circumstances play, she's still a 17-year-old girl. And she acted with what she had, her experiences. But what we need to look at is the defendant's behavior and look at his actions and how that put her at risk, what he did to her, and how he held her and wouldn't let her leave, how he put her at risk with his firearm, how he attempted to control her over and over in this situation. Go back and look at that video and see what risk and what fear he put her in. Thank
Thank you. Mr. Bulger for the defense. Yes.
Ladies and gentlemen, this is my last opportunity to speak to you because the state bears the burden of proof and proof beyond a reasonable doubt of every element of the offenses that they've charged against Tyler Maynard. They get to rebut. They get to stand back up and address what I've said. I won't have that opportunity, so I got to get it out now. We have a young couple. There are certain pathological features to the relationship. I think we understand that. They're deceptive with respect to her grandmother. She doesn't realize that they've gone to Jackson County to spend the night with my client Tyler's mother, who has become familiar with them, has provided them these opportunities on more than one occasion, apparently. The plan is to leave and to travel to Ashland, Ohio for the purpose of selling a couple of cats that morning. That's what they're up to. They come into this town. We don't know of any connections whatsoever that Nicole Hinkle had with Jackson, Ohio. They're now in a scramble over finances. Nicole wants to pay $50 for driving her 2 hours and 40 minutes to Ashland, Ohio, and making the return trip. He's not going for it. This is apparently the source of the argument that takes place and causes a bad feeling that occurs between them as they travel down to this filling station, having gone to the Dairy Queen that morning. Now, there isn't really any dispute as to what happened in the car at all. They both gave the same account. You heard Nicole on the stand. You heard, and we'll hear it again perhaps, Tyler's responses to questions from the interrogating officer that day. And those recollections that they made, they're pretty much the same. She said she was in a bad mood, that she kept nagging him on. Well, that doesn't justify what happened in that car, and I'm not pretending to suggest to you that what he did in that automobile that day is not criminal. When you put someone in it knowingly, cause them to reasonably believe that you were going to cause them serious physical harm, that is a crime under Ohio law. It's not the crime charged in the indictment, but it's a crime. If you take somebody by the back of the neck or by their hair and you push them down like that, that can be considered either knowingly causing or attempting to cause physical harm, another crime under the law of Ohio, but not the crime charged in the indictment. What is it that Tyler Maynard is trying to stop Nicole from doing in that filling station parking lot at the pump where we see things happening? He's trying to stop her from exiting the vehicle and taking off on foot in a town she has no connections with. And he explained to the officer who interrogated him that evening why he didn't want her doing that, because he understood that for a 17-year-old girl without any connections in the town and no way, not even a driver's license, what's going to happen to her? Nobody knows. He didn't know. And that apparently set him off. And what did he say to her in her own written statement? She records it. Stop. I'll kill you, please. What's the please about? This is something I think that indicates behaviors that have perhaps even occurred in the past. That this is not a unique situation to either one of these youngsters. And when she gets out of the car, just let her go, she's out of the car, she runs across the lot. She doesn't go to the convenience store in front of her. She goes across the lot, she's yelling, People are alarmed necessarily. And he follows her out. Now, we've got their account of what happens that corresponds to what we see in the video. But Ms. Mullins comes in here this morning and what she has testified she supposedly saw a year ago doesn't bear any correspondence to what you see on the video. You know what you saw, and you'll see it again if you want to. He does pursue her across the lot. She backs up. He comes closer. She shoves him. She backs up a little bit more. He comes forward. She shoves him again. And then there's a hug. And at that point, they both depart for the car. He at one point approaches her and seems to have a hand on an elbow. She splits off, goes to the passenger side and gets in. He goes to the pump and abandons his apparent intent to put antifreeze in the vehicle before they start to Ashland. That's what they're at the filling station for, to get the car ready to go to Ashland. She tells you under oath that she got in the car willingly. Is that an abduction at that point? Is it a kidnapping? She tells you that she saw, as he approached her on the parking lot, as she's backing up, he's coming forward, she's shoving him. She says she saw the change, something she'd seen before. She was no longer concerned about what he was up to. That's why she willingly went back to the car. That's why she willingly got into the car. Why she told him, let's get out of here, words to that effect, let's go, forget the antifreeze, because she understands what? Not any fear of his behavior at that point at all, but that the police are going to be called and that they're going to arrest Tyler. That's why she wants him to go. And where do they go? She, according to Tyler and his recollections to the officer that night, that very day, the occurrences that were still fresh in his mind, that on their way away from the filling station, her GPS is continuing to give them instructions to Ashland. And that's where she wants to go. She wants to go with this guy on a 5-hour trip to make some money on a cat sale. He doesn't want to go there anymore. Where does he want to go? He wants to go back to his mom's house in Oak Hill. So what's he doing? Kidnapping Nicole Hinkle to his mother's house, abducting Nicole Hinkle to his mother's house. When you see that video of the stop, what demeanor do you detect in Nicole Hinkle? Do you see a terrorized individual? Now remember, she's being held at essentially gunpoint, asked to walk backwards, hold her hands up and kneel, and then she's handcuffed. So this is a stressful situation for any 17-year-old, for anybody it would be. But what is her demeanor? Is she collected? Is she calm? What is she concerned about? Oh, I'm so glad you saved me. No. What's she concerned about? What's going to happen to my babies? And who's she talking about? She's talking about 4 kittens and a guinea pig in the back seat of that car. Is that a demeanor and a concern that is consistent with a person who has been purposefully terrorized? I would suggest to you not. Now, there are certain elements in every criminal offense. They provide a framework from which you are to insert essentially facts as you find them. It becomes an easy task in a case like this to identify the framework for mishandling a firearm in a motor vehicle. And the facts, they fit that framework exactly. And I would not suggest to you that there is any argument to be made that Tyler did not violate that particular provision of our criminal code, that he mishandled a firearm in that motor vehicle. That's a fact. An easy one for you to fit into the elements of the offense because they're all there. But when you come to kidnapping, You're dealing with a framework that has been chosen by the prosecutor, not a framework that involves statutory elements that actually fit the facts, but those that have been presented to you. And what you're essentially being asked to do is to take a square peg and fit it in a round hole. There are criminal offenses that Tyler committed that day, but kidnapping is not one of them. There are offenses that he committed in that automobile, but abduction is not one of them. And in this particular case, the victim has come in here and told you, the alleged victim has, I wasn't kidnapped. Are you going to just disregard that? Now, I'm not suggesting that there isn't something really wrong and disturbing about this relationship that exists between these two people. And you understand that this deputy, he's not sitting in this courtroom for no reason at all. Tyler's in custody, has been. What I'm asking you to do is to pay attention to the features of these individual personalities, to understand what was really going on in that car. Yeah, he never should have done that. He never should have pointed a gun at her. He never should have threatened to kill her. But he didn't. He didn't try to harm her in any way. She doesn't have a bruise. She doesn't have a red mark. She doesn't have a scratch. He's supposedly abducting her with purpose to cause serious physical harm. He had a loaded weapon that's operable. He didn't shoot her. He didn't do anything to her. It's a disturbing situation. It's not an easy situation for you. And the reason it's not easy is because you've been given the wrong framework in which to fit the criminal behavior of Tyler Maynard that day. You've been given a first-degree felony instead of a first-degree misdemeanor. I ask you to take careful consideration of what you're really dealing with in this case. It's got to be frustrating in some ways for you when you're struggling to try to make sense out of how to fit the facts that you're determining into a framework where they just don't seem to work. And even the person that's supposed to be the victim of the crime tells you it didn't happen. Somebody that knows him better than anybody in this courtroom, probably, except for maybe his parents. I would suggest to you, this young man, he needs help. If you pay attention to what you're doing right now, and I think he will have to be satisfied with the outcome. He has waited for this day for a long time. It's come, and now it's in your lap. I hope what I've said makes some sense to you. And I hope that you have an opportunity and take the opportunity to review his interview, to take a look again at the filling station footage, to understand that what you see from the filling station is something that an unknown person at that station, we don't even know who it was, decided was important for the police to have, and that's it. No police officer even bothered to supervise what footage was extracted from those security cameras. Are there other cameras that have footage? We don't even know that. Well, good luck.
Thank you. Ms. Williams?
Thank you. When we began our trial, we talked about the fact that what the attorneys say is not evidence. You'll have the opportunity to review what in fact was evidence or what is evidence. And that's what you saw or heard from the witnesses in the courtroom. That is what evidence is. And through those witnesses, and through that evidence, you will not see any information about the need to protect Nicole Hinkle from herself. The need to protect her from a public area, a gas station, from being far from home. That's not why he did this. He didn't hold a gun to her side to be the kind boyfriend who makes sure that she's safe and free from harm, able to get home with her kittens. That's not what the evidence will show. He didn't do this for her greater good. He did it to control her, to keep her with him, to keep her from leaving him, to keep her from calling the law on her. Not to help her, not to save her, not to keep her safe. That wasn't his purpose. When you look at the evidence that was presented and review the video, you will see that he says he did it to scare her, to threaten her. That's the only way she would stop. He needed to keep her in the car. You have the opportunity to review those videos that clearly show what happened. The videos that provide all of the information testified to by both Nicole Hinkle and provided by the defendant. There isn't anything missing in those videos, and that's an attempt to in fact, distract you from the truth. When you have the opportunity to review the videos, you will show that they show exactly what the parties said happened. That they went to the gas station, that she attempted to get out, and that he restrained her liberty from doing so. And he did this not by just grabbing her and pulling her back into the car, but also by sticking a firearm in her side and threatening to kill her. It is at this point that both the kidnapping and the abduction took place. She had then attempted to get out and run away from him, at which point he pursued her. He followed her out into that parking lot. He made sure she got back into that car. Watch that video. Watch how close he was behind her. Watch how many times she retreated from him and how many times he then aggressively pursued her, following her directly back to the car. That behavior is what caused her to get into that car. So whether she says she went in voluntarily or whether she says she did not is irrelevant at that point. It's his behavior that we're looking at. I would also ask you not to get distracted by the fact that it was brought up that he didn't do it to cause her physical harm, because that's not what's required. It's not required that he had to shoot her, that he had to leave bruises on her, that he had to pull her hair. That is not what's required. It's required that he use either force or threat of force to restrain her liberty. And that's what he did. That's what he did in that car. That's what he did. There's no requirement that he meant to cause her physical harm. What he meant to do was scare her. What he meant to do was stop her and prevent her from leaving. And that's what's required. Look at exactly what she's charged with, what the elements of the offense are. Look at what he says he did, why he says he did that. And when you do that, you can look at what he says, viewing it, you can believe part, you can believe all of what he says. We already know that he didn't tell the officer the truth initially when he was asked, why do you have a fanny pack on your chest? We know it was only when he was confronted with the fact that no one carries a fanny pack like that, did he then say, well, yes, I had a firearm in there. You had the opportunity to look at everything in the light of all the testimony and how it fits together and what you see in the video. The behavior that prompted the police to come. Don't be distracted by information that perhaps the store clerks didn't get all of the videos and maybe it would show you something else. Because from the testimony you heard, those videos accurately portrayed what happened and the best ability that they had. They didn't have the ability to see under the car, but you can look at what happened and what they say happened and make decisions from that, even though you can't directly see into the car. The videos that were provided accurately depict what occurred. Watch the videos, you can review the audios, and then review what is required under the law and see if it fits. Once you do, and you see that this isn't just one action, it's pulling her back in, it's putting a firearm to her side, it's threatening to kill her in order to keep her from getting out of that car, review that. You'll find that if it's a kidnapping statute, the abduction statute, and that clearly he's violated the firearm charge. Thank you. Appreciate your time.
Thank you, counsel. Ladies and gentlemen, I'm now going to give you your closing instructions. You will get a copy of these to take back with you, so it's not necessary that you try to memorize what I'm about to read to you. It's more important that you listen to it and take it in. Members of the jury, you've heard the evidence and the arguments of counsel. The court and jury have separate functions. You decide the disputed facts, and the court provides you with the instructions of law. It is your sworn duty to accept these instructions and apply the law as I give it to you. You are not permitted to change the law or to apply your own idea of what you think the law should be. The case before you began with the filing of an indictment. The indictment informs the defendant that he has been charged with a crime. You may not consider the fact that it was filed for any purpose. A plea of not guilty is denial of the charge and puts at issue all the essential elements charged in the indictment. The defendant is presumed innocent until his guilt is established beyond a reasonable doubt. The defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the offense charged in the indictment. Reasonable doubt is present when, after you have carefully considered and compared all the evidence, you cannot say you are firmly convinced of the truth of the charge. Reasonable doubt is a doubt based upon reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of the person's own affairs. Evidence is all the testimony received from the witnesses and the exhibits admitted during the trial and any facts that the court requires you to accept as true. You may consider both direct and circumstantial evidence. You must decide from all the direct and circumstantial evidence taken together whether the state has proven all of the elements of the charged offenses beyond a reasonable doubt. Evidence may be direct, circumstantial, or both. Circumstantial evidence and direct evidence are of equal weight. Direct evidence is the testimony given by a witness who has seen or heard the facts about which the witness testifies. It includes exhibits admitted into evidence during trial and stipulations that you were instructed to accept as fact. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts that naturally and logically follow according to the common experience of people. To infer or to make an inference is to reach a reasonable conclusion or deduction of any fact that you may, but are not required to make from other facts that you find have been established by direct evidence. You may infer a fact or facts or reach a reasonable conclusion about a fact or facts only from other facts or circumstances that have been proven by the greater weight of the evidence. Whether an inference is made rests solely with you. The evidence does not include any statement made by counsel during trial unless such statement was an admission or agreement of certain facts. The opening statements and closing arguments are not evidence. They are designed to assist you in evaluating that evidence. The evidence does not include any statements that were stricken by the court or that you were instructed to disregard. You may not speculate why an objection was sustained to any question or what the answer to that question might have been, because these are questions of law and rest solely with the court. You may not speculate as to why the court sustained an objection or what the answer to such question might have been. You may not draw any inference or speculate on the truth of any suggestion included in a question that was not answered. You are the sole judges of the facts, the credibility or believability of the witnesses, and the weight of the evidence. To weigh evidence, you must consider the credibility of the witnesses. You will use the tests of truthfulness that you use in your daily lives. These tests include the appearance of each witness upon the stand, the witness's manner of testifying, the reasonableness of the testimony, the opportunity the witness had to see, hear, and know the things about which the witness testified, and the witness's accuracy of memory, frankness or lack of it, intelligence, interest and bias, if any, together with all the facts and circumstances surrounding the testimony. Use these tests and assign to each witness's testimony such weight as you think proper. You are not required to believe the testimony of any witness simply because the witness was under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your duty to decide what testimony to believe and what testimony not to believe. The testimony of one witness, if believed by you, is sufficient to prove any disputed fact. A number of exhibits and the testimony related to them have been introduced throughout the trial. You will decide what weight, if any, the exhibits should be given in light of all the evidence. These exhibits may include, but are not limited to, documents, reports, video and audio exhibits, and other physical items. The numbering or lettering of these exhibits that you take to the jury room may not follow consecutively. There are reasons for this. An exhibit may not have been submitted. May not have been submitted by the party who produced it during the trial, or the court may not have admitted an exhibit because of a legal or procedural reason or ruling. Do not draw any inference because you do not have a particular exhibit. You will have in the jury room the verdict forms and all the exhibits received into evidence during the course of the trial. You will not be given any other exhibits during your deliberations. It is not necessary that the state prove that the offense was committed on the exact day as charged in the indictment. It is sufficient to prove that the offense took place on a date reasonably near the date claimed. It is not necessary that the defendant take the witness stand in his own defense. He has a constitutional right not to testify. The fact that the defendant did not testify must not be considered for any purpose. This is count one. The defendant is charged with kidnapping. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 30th day of July, 2020, and in Jackson County, Ohio, the defendant, by force, threat, or deception, did restrain Nicole Hinkle of her liberty for the purpose of terrorizing or inflicting serious physical harm to Nicole Hinkle. Force means any violence, compulsion, or constraint physically exerted by any means upon or against a person or thing. Threat means a statement and or conduct, whether direct or indirect, exerting pressure sufficient to overcome the will of another or to make another fearful or apprehension of injury or harm. Deception means knowingly deceiving another or causing another to be deceived by any false or misleading representation, by withholding information, by preventing another from acquiring information, or by any other conduct or admission that creates or confirms or perpetuates a false impression in another, including a false impression as to the law, value, state of mind, or other objective or subjective fact. A person acts purposely when it is the person's specific intention to cause a certain result, or when the gist of the offense is a prohibition against conduct of a certain nature, regardless of what the offender intends to accomplish thereby. It is the offender's specific intention to engage in conduct of that nature. Restrain of her liberty means to limit or restrain Nicole Hinkle's freedom of movement. The restraint need not be for any specific duration of time or in any specific manner. If you find that the state proved beyond a reasonable doubt all of the essential elements of the offense charged, let me start that over. If you find the state proved beyond a reasonable doubt all the essential elements of any one of the offenses charged in the separate counts in the indictment, your verdict must be guilty as to such offense or offenses according to your findings as to the defendant. If you find the state has failed to prove beyond a reasonable doubt any one of the essential elements of any one or more of the offenses charged in the separate counts in the indictment, your verdict must be not guilty as to such offenses or offenses according to your separate findings as to the defendant. The charges set forth in each count of the indictment, kidnapping, abduction, and improperly handling firearms in a motor vehicle, constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count separately, and you must state your finding as to each count uninfluenced by your verdict as to the other count. The defendant may be found guilty or not guilty on any one or all of the offenses charged. Count 2. The defendant is charged with abduction. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 30th day of July, 2020, and in Jackson County, Ohio, the defendant, without privilege to do so, knowingly by force and or threat, restrained Nicole Hinkle in her liberty under circumstances that created a risk of physical harm to her and or placed her in fear of her life. Privilege means an immunity, license, or right conferred by law or bestowed by express or implied grant or arising out of status, position, office, or relationship or growing out of necessity. A person acts knowingly, regardless of his purpose, when he is aware that his conduct will probably cause a certain result, or he is aware that his conduct will probably be of a certain nature. A person has knowledge of circumstances when he is aware that such circumstances probably exist. Force means any violence, compulsion, or restraint physically exerted by any means upon or against a person or thing. Threat means a statement or conduct or nonverbal signaled cue, whether direct or indirect, exerts pressure sufficient to overcome the will of another or to make another fearful and or apprehensive of injury or harm. Restrain one of her liberty means to limit or restrain Nicole Hinkle's freedom of movement. The restraint need not be for any specific duration of time or in any specific manner. If you find the state proved beyond a reasonable doubt all the essential elements of any one or more of the offenses charged in the separate counts in the indictment, your verdict must be guilty as to such offense or offenses according to your findings as to the defendant. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of any one or more of the offenses charged in the separate counts in the indictment, your verdict must be not guilty as to such offenses or offenses according to your findings as to the defendant. The charges set forth in each count in the indictment, kidnapping, abduction, and improperly handling firearms in a motor vehicle, constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count separately, and you must state your finding as to each count uninfluenced by your verdict as to any other count. The defendant may be found guilty or not guilty of any one or all of the offenses charged. Count 3, the defendant is charged with improperly handling a firearm in a motor vehicle. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 30th day of July 2020, and in Jackson County, Ohio, the defendant knowingly transported and/or had a loaded firearm in a motor vehicle in such a manner that the firearm was accessible to the operator without leaving the vehicle. A person acts knowingly, regardless of his purpose, when he is aware that his conduct will probably cause a certain result and/or he is aware that his conduct will probably be of a certain nature. A person has knowledge of the circumstances when he is aware that such circumstances probably exist. Firearm means any deadly weapon capable of expelling or propelling one or more projectiles by the action of an explosive or a combustible propellant. Firearm includes an unloaded firearm or any firearm that is inoperable but that can readily be rendered operable. Had means possessed. Possession of a firearm is an essential element of the offense of improperly handling firearms in a motor vehicle. Possession is a voluntary act if the possessor knowingly procured or received the firearm or he was aware of his control thereof for a sufficient period of time to have ended his possession. A person has possession when he knows that he has the object on or about his person or property or in places where it is accessible to his use, and he has the ability to direct or control its use. Loaded means ammunition in a firearm in question in any one of the following. One, there was ammunition in a magazine or speed loader that was in the vehicle in question and that could have been used with the firearm in question, or any magazine or speed loader that contained ammunition that could have been used with the firearm in question, was not stored in a compartment within the vehicle in question, and that could have been accessed without leaving the vehicle, or was not stored in a container that provided complete and separate enclosure. A traffic stop is where a police officer stops a vehicle based upon probable cause that a traffic violation has occurred or was occurring. If you find that the state has proved beyond a reasonable doubt all of the essential elements of any one or more of the offenses charged in the separate counts in the indictment, your verdict must be guilty as to such offenses or offenses according to your findings as to the defendant. If you find the state has failed to prove beyond a reasonable doubt any one of the essential elements of any one or more of the offenses charged in the separate counts in the indictment, your verdict must be not guilty as to such offenses or offenses according to your findings as to the defendant. The charges set forth in each count in the indictment, kidnapping, abduction, and improperly handling firearms in a motor vehicle constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count separately, and you must state your findings as to each count uninfluenced by your verdict as to any other count. The defendant may be found guilty or not guilty of one or all of the offenses charged. The court has instructed you on the law necessary for your deliberations. I will now instruct you on how to conduct your deliberations and prepare the verdict forms. You will have with you in the jury room the following verdict forms. The order I go over these forms has no significance. You would have a guilty form. You would have a form entitled Guilty Verdict Form for Abduction. You would have a place, if you find guilty, for signatures. If you find not guilty, there's a corresponding verdict form for you to sign. There is a not guilty verdict form for improperly handling firearms in a motor vehicle, and there is a corresponding guilty form. And then you will sign this form depending on which finding you make, guilty or not guilty. Likewise, there is a guilty verdict form for kidnapping and a not guilty verdict form. And there are places for your signature, and you will fill that out according to what you find. When you've reached a verdict, you will complete the forms that correspond to your decision and sign the verdict forms in ink. You must not be influenced by any consideration of sympathy or prejudice. It is your duty to carefully weigh the evidence, to decide the disputed questions of fact, to apply the instructions of law to your findings, and to render your verdict accordingly. Your duty as jurors is to arrive at a just verdict. Consider all of the evidence and make your findings with intelligence and impartiality and without bias, sympathy, or prejudice, so that the state of Ohio and the defendant will feel that their case was fairly and impartially tried. During the course of the trial, the court said or did anything that you consider an indication of the court's view of the facts, you are instructed to disregard it. It may be difficult for you to remember all the instructions I've given you. If during your deliberations you cannot remember or are in doubt about a portion of the instructions, you may request such information. The foreperson must put your question in writing, indicate specifically what is requested, and you must deliver such communication to the bailiff. You may not discuss or consider the subject of punishment. Your duty is confined to deciding the guilt or innocence of the defendant. In the event that you make a finding of guilty, the duty to decide punishment is placed by law upon this court. Your initial conduct upon commencing deliberations is important. It is not wise to express immediately a determination or to insist upon a certain verdict. Having so expressed yourself, your sense of pride may be aroused, and you may hesitate to give up your position, even if it is shown that it is not correct. Consult with one another in the jury room and deliberate with a view to reaching an agreement if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself. You should do so, however, only after a discussion of the case with other jurors. Do not hesitate to change an opinion if you are convinced it is wrong. You should not consider your considered opinion concerning the weight of the evidence, however, in order to be congenial to reach a verdict solely because of the opinion of other jurors. Those of you selected as alternate jurors to serve on this jury panel must remain and be sequestered until the jury has returned its verdict in open court. A juror selected as an alternate is not permitted to participate in the jury's deliberations unless one of the deliberating jurors is found by the court to be unable or disqualified to perform his or her duties. You'll be taken to the law library apart from the jurors and will remain there under the direction of the bailiff until the verdict is reached. The alternate jurors will not accompany the jury to the jury room or participate in deliberations unless directed by the court. Alternate jurors continue to be part of the jury panel while the other jurors are deliberating until fully released from this case by the court. Alternate jurors are required to follow all of the court's orders concerning the conduct of the jury. You shall not discuss this case with anyone or each other or tell anyone how you would have voted until you're released from this case by the court. On behalf of the public and the parties, I'd like to express appreciation for your service in performing this important public function. After your verdict is reached, your jury services are completed. You may discuss this case with anyone, but you are not required to do so. Whether you discuss this case with counsel or anyone else after you are discharged is a matter of your own free choice. The court will place in your possession the exhibits and the verdict forms. The foreperson will retain possession of these records, including the verdict, and return them to the courtroom. The foreperson will see that your discussions are orderly and that each juror has an opportunity to discuss this case and to cast his or her vote. Otherwise, the authority of the foreperson is the same as any other juror. Till your verdict is announced in open court, you are not to disclose to anyone else the status of your deliberations or the nature of your verdict. So Ladies and gentlemen, we will give you a copy of the instructions, the verdict forms, and the exhibits. Yeah. Yes.
A concern that I have.
Okay.
I'm sorry, I did not see this beforehand. There's a here, these ones are required by the statute. It should have stopped right there.
Where are you?
These three words are not required. Under the statute, they shouldn't have been put in there. It was a mistake.
Okay.
So,
Do you want me to reread that one paragraph?
I think that'd be the best way to proceed.
Send it back, just have that.
Yep. So ladies and gentlemen, at some point, if you wish to review the videos, we have the equipment here in the courtroom. We would bring you back in. When you're watching the video, we can't discuss anything with you. You have to stop your deliberations. You simply would come back into the courtroom, review the video, then when you're done, you'd go back into the jury room and continue your deliberations. And as to count two, I need to reread a section. That's the abduction count to you, because there's some language that was included that we now have taken out. The defendant is charged with abduction. Before you can find that the defendant guilty, you must find beyond a reasonable doubt that on or about the 30th day of July 2020 and in Jackson County, Ohio, the defendant without privilege to do so, knowingly by force and or threat restrained Nicole Hinkle of her liberty under circumstances that created a risk of physical harm to her and or placed her in fear. Is there anything else from counsel?
No.
Okay. All right, ladies and gentlemen, you will now retire to the jury room. We will get you the verdict forms, the exhibits, and a copy of the jury instructions. All right, thank you.
Here's one go to the law library, so yeah, you wanna hang out right quick?
Counsel, if you would approach, and everyone else can be seated. On count three, you've had 21, so I changed that to 20.
Right.
Yeah.
And then on count two, I simply, is that sufficient to send this version back to them then? Okay. Okay. And then I will need, do I have the exhibits?
They're right there in that, middle.
Okay. Do they have pens?
Yes. Look on my books.
Okay, we'll take it back in.